Hello everyone, welcome to Legal Darshan. In continuation with our previous video regarding part 8 of CPC, today we are continuing with review section 114. As said earlier, the Code of Civil Procedure guarantees certain remedies to appellants or respondents or plaintiffs to go in the court again and appeal the matter or put it in review petition, reference petition or revision. So in this video we are going to talk about review. Now review is provided in section 114 of the code, and order 47 of the code elaborates its conditions and terms. It is the remedy given to a person who finds himself aggrieved, that is, he finds himself the sufferer of the decision which the court has made. So again, subject to such conditions and limitations that are prescribed, any court can entertain review petition provided that the matter has been decided by this court. So the section reads, any person considering himself aggrieved by a decree or order from which an appeal is allowed in the code but there lies no appeal, by a decree or order from which no appeal is allowed, or by a decision on a reference from court of small causes, may apply for a review of judgment to the court which passed the decree or made the order, and the court may make such order thereon as it thinks fit. So where this clause comes as it thinks fit, it provides the discretion to court either to entertain the review petition or not. So the reconsideration of decision is basically put forward in review by the same bench of judges in the same court. Any aggrieved person can file the review within 30 days of the decision of the decree or order issued to him. There must lie non-appealable cases or appealable cases from which no appeal has been made. If there is any appeal made out of the appealable cases and the review is filed on the same matter, res judicata will apply. So the court would not entertain the review petition. Review can also be filed if the person consider himself the sufferer by a decision on a reference from the court of small causes. The person may apply for the review within 30 days, which is the limitation period of filing the review, under certain conditions and criteria which is given in order 47 of the code. Order 47 lays certain guidelines, certain circumstances in which the court will entertain the review petition. Because here is a clause said that the court may make such order thereon as it thinks fit. So what are those conditions in which court is going to think that it can take the matter is fit to be taken? That all is given in order 47 of the code. So Order 47 in its rule 1 tell important conditions under which a person can go into review. So like suppose let's say there is a case A and B got divorce decree from family court, and B wants to put it for the review. The court will take its petition for review only if there are sufficient cause, only if there are certain grounds that are provided in 47 order 47, not on any ground that the party is presenting. So what are these grounds? There must be some prima facie mistake or error on the face of record. So there must lie that the court has misinterpreted or the court has made a mistake in guessing the case right, or the evidence could not be produced by either parties who is considering himself to be aggrieved even while exercising the due diligence, and the evidence were not within his knowledge, and the evidence were of important matter, or any other sufficient cause. Now there is a key word here, sufficient cause or sufficient reason. It includes misconception of a fact by law, a court, or even a legal personnel. So an application for review will be necessitated in such case. Sufficient cause basically lies on the discretion of the court. If the court finds it sufficient enough to take into the review, it can take it. Now the rule 2 of the same order says that if an aggrieved party is not appealing from the decree or order, it may be applied to review notwithstanding the pendency of any appeal that some other party has made, except if the ground of both the cases is same. That is, the same case has been presented into review by one party and into appeal by another party. In such a case, the person who is applying for review will present as respondent in the appellate court. Now, there is a case associated with it, the case of Haridas versus Usha Rani Banik. In this case, there are two respondents, Usha Rani Banik and Kalipada. What happens is Kalipada enters into an oral agreement with the plaintiff Haridas for the sale of his property for rupees 46,000. It is decided that Kalipada will give the property to Haridas after 3 years on the payment of 46,000. So as decided, Haridas paid 14,000 in first year, 31,000 in next year, and 1000 is remaining for the last year. Meanwhile, the respondent number 2, Kalipada, executes a sale deed in favor of respondent number 1, Srimati Usha Rani Banik. So, in order to protect his possession, the appellant filed a suit in the court asking for the possession of the property. So, the court issues an interim order directing Kalipada to maintain the status quo in respect of the suit property. The sale deed executed for Srimati Usha Rani Banik was cancelled and appeal against such an order was allowed. Now, the High Court gives the decision in appeal and the review petition against such a decision was filed. Now, the issue is whether in such circumstances review could be allowed or not. The case is based on Order 47 Rule 1, which mentions sufficient cause to be the reason of review petition. So, in this case, the Supreme Court observed that under Order 47 Rule 1 of CPC, a judgment may be open to review inter alia if there is a mistake or an error apparent on the face of the record, an error which is not self evident and has to be detected by a process of reasoning, can hardly be said to be an error apparent on the face of record, justifying the court to exercise its power of review under Order 47 Rule 1 of CPC. Here, it is not permissible for an erroneous decision to be reheard and corrected. Therefore, a review petition must be remembered that it has a limited scope. It cannot be allowed to be an appeal in disguise. Therefore, Supreme Court in this case held that the High Court has clearly fallen in error in accepting the prayer for review. The order of the High Court for review was clearly contrary to the law and was set aside, and the appeal in this case was further allowed. Hence, it can be said that review has a limited scope and the court must exercise it in the limited scope, not taking it as the appeal procedure. This was all for review today. Thank you so much for watching. Please like, share and subscribe this video. For any suggestions, feedbacks or queries, please feel free to contact us at legaldarshan@gmail.com.